Right, so let's take a look at the last non-fatal offences against the person, which is grievous bodily harm, section 18. And frequently, I'll refer to it throughout this video, but frequently it's referred to as GBH with intent. It's referred to GBH section 18, or more often than not, very frequently, particularly if you're amongst other lawyers, just as section 18, a section 18 offence. And this will be the last of the non-fatal offences against the persons videos that we're going to look at in the short term. So, we're now at the very top of our pyramid. We're at the most serious of all of the non-fatal offences. And it's so serious that it's triable on indictment only. So it's an indictable only offence, which means that it can only be tried in the Crown Court. And the outcome of that is that the maximum sentence for GBH with intent is life imprisonment. Maximum sentence, remember. And that has nothing to do with the actus reus. And the actus reus is wounding or causing GBH. Actually, the actus reus is the same as it is for the section 20 offence. Why this is different is because it's an issue of intent. And because of that, this video will take a short period of time, just visiting very quickly the actus reus elements, before we're going to spend much more time looking at the intent. And the intent is slightly more complex. So if you want to go back and look in depth at the actus reus, then please go back to the section 20 video where we'll cover it in much more depth, and it's the same. This section 18 video, this one, we're going to spend an awful lot more time looking at specifically the intent. And because somebody intended to cause that level of harm, they intended to hurt somebody that much, that's reflected in the severity of the sentence. So the intent, the mens rea, is driving the sentence. The definition for section 18, it's got a lot going on in it, to be fair. Whosoever shall unlawfully and maliciously wound or cause any grievous bodily harm with intent to do some grievous bodily harm or to any person, to do some grievous bodily harm to any person, or with intent to resist or prevent the lawful apprehension or detainer of any person, shall be liable to imprisonment for life. There's an awful lot going on in that definition. And especially when you start to break it down, you can see that it's got two clear levels of complexity. The actus reus is not difficult. The actus reus remains the same. It's the wounding or the causing of grievous bodily harm. So those two things together clearly go to make our actus reus. Of course, we've got the issues of causation and we've got the issues of unlawfulness, but at its heart, it's about wounding and it's about GBH. The mens rea has two clear levels. The first, let me change the colour of the pen just to do this for a moment. The first is the notion of maliciously. So level 1 is the idea about malicious wounding or the malicious causing of grievous bodily harm. And as we'll see later, that has the same meaning as it does for section 20. The second level is there's a with intent to. And the with intent to is to do some grievous bodily harm or to resist or prevent the lawful apprehension or detainer. Now we'll look at that in much greater depth when we look at the intent element of this video. But two layers. The malicious wounding or causing any grievous bodily harm, level 1, with intent to do grievous bodily harm or resist arrest, level 2. If we've got the actus reus, plus those two levels of mens rea, and an absence of a defence, and we don't talk about those in these videos, we will talk about them in subsequent videos, then we have criminal liability. Now, recall from our last video that we have to charge with the right actus reus. Is it a wounding or is it GBH? So just make sure, again, I'm going to visit these things very quickly, but if you want to go back over what those things mean, revisit the section 20 video. But this is new. This is a chart which demonstrates the 4 different permutations, or the 4 different ways in which GBH with intent can be committed. Now I'm going to start by saying something very clear. Section 18 is a specific intent crime, which, as you'll all remember, means it can only be caused or can only be committed with intent, either direct or indirect. It cannot be caused recklessly. It cannot be committed with a reckless intent. Now I say that clearly at the beginning because of this word here. And malicious, as you'll see later, has the same meaning as section 20. And if you recall, in section 20, malicious means either with intent or recklessly. Now please, please, please do not allow the use of this word to confuse you. Section 18 remains a specific intent crime that can only be committed with either direct or indirect intent. But what I want to do is I want to draw a line here to demonstrate the 2 key levels. So level 1 is the malicious causing of grievous bodily harm or the malicious wounding. So the actual injury can be caused either with intent or recklessly. Level 2 is the intent, the section 18 intent level. And level 2 says that that malicious wounding or that malicious GBH has to be done with an intention to cause grievous bodily harm or to resist arrest. So the 4 ways in which this offence can be committed is a malicious wounding in which the defendant intends to cause grievous bodily harm or intends to resist arrest, or it can be committed through a malicious GBH with an intention to cause grievous bodily harm or to resist arrest. Now for me there are 3 things going on there. The first is that there is no wound, and I'll cover this again later. If you intend to wound somebody, that's not good enough. You can wound somebody, but the intention of that wound has to be a level of really serious harm. The second thing for me is that there is this notion of the resisting of arrest. So let's have a think about how that might work. How there might be a malicious wounding or GBH which leads to a resistance of arrest, an intention to resist arrest. Let's suggest that I've stolen some sweets from the local newsagents. On my way out of the door, a policeman sees me and tries to arrest me. I run past the policeman and gently push him out of the way. My intent is not to cause him really serious harm. Unfortunately, he trips over when I push him and cracks his head open on the pavement. My actions, pushing him over, have amounted to what is in essence a reckless GBH. The man has a split skull, and he has that split skull because I caused him GBH. Now, under normal circumstances, that would be sufficient for a Section 20 offence. But because I've recklessly caused him grievous bodily harm, with an intention of resisting the arrest, I am now liable for the Section 18 offence. Of course, the more obvious is that I intend to cause somebody GBH by punching them in the face, and I intend to hit them so hard that I break their jaw. That would be a straightforward malicious causing of GBH with intention to cause GBH. Now, I'm not going to do that for all permutations, but I hope you can see how, when we think about it in those terms, how the 4 permutations become obvious. And I will re-go over, or I'll recover those at the end when we look specifically at mens rea. So, I'm going to focus now on the actus reus element, and I'm going to look at the same things that we looked at in the section 20 offence, but very, very quickly. In the first instance, DPP versus Smith tells us that GBH means really serious harm. And we use subsequent case law to help us define what we mean by really serious harm. And I suppose it might be best to start off with R.V. Stratton, although I'll go a different way. R.V. Stratton says that what amounts to grievous bodily harm is objectively assessed. It's a reasonable man test. Effectively, it's objective. So the jury will decide what really serious harm means. And that's Brown and Stratton 97. And I'll come back to Brown and Stratton as well in a moment. We also have to consider, when we think about what really serious harm is, are the characteristics of the victim. And here, age plays an important part. If the victim is very young or very old, then what might amount to an ABH on a normal, healthy 30 or 40-year-old could easily amount to a GBH on a very small child or a very frail old person. So R versus Bollum 2004 says that we have to consider the characteristics of the victim, and what they mean in terms of that is the age. Brown and Stratton, back to Brown and Stratton 1997, if you remember, that's the transvestite that is beaten up by his father and some of his father's friends. That also says that we can have a number of small ABHs, when put together, could make a grievous bodily harm. So there can be a cumulative effect that can amount to GBH. And finally, GBH includes now psychiatric harm, and that's because of R versus Burstow. If you recall, Chan Fook did the same thing for ABH. So that's its psychiatric harm for ABH. Burstow says that GBH can include psychiatric harm. The second element is this notion of wound. What makes up a wound? And a wound, as we found out from Moriarty and Brooks, is a break in continuity of all layers of the skin. So that's all layers of the skin. And remember, the key way of seeing that is blood flows freely. So blood will flow freely from that break in continuity of the skin. And generally that's 2 layers, the dermis and the epidermis. But we could also say it's 7 layers if we're going to look at the amount of numbers of layers of skin that make up the dermis and the epidermis. But the essential element is to form or to constitute a wound, all layers of the skin have to be broken and blood should be allowed to flow freely. Now, to define that further, we looked at C. Minor versus Eisenhower, 1984 case. And I've just noticed on here that says GBH. That should say wound. So please apply that to the section 20 video till I get a chance to re-record it. But what C versus Eisenhower says is that internal rupture of blood vessels is not a wound. If you recall, in Eisenhower, a bullet, an air pellet, was shot just above the eye into the eyelid, and the blood and the eye bled internally. And the judge said very clearly that the internal rupture of the blood vessels in the eye was not a wound. So therefore, internal bleeding would not be a wound. It would be a GBH perhaps, but it would not be a wound. And finally, I just want to revisit the joint charging standards. If you recall, I was very, very clear with you when I said I do not want you to rely on the joint charging standards to be the determinant of the level of harm. I want you to use the actus reus and use the mens rea and your key cases to help you to decide what we mean by GBH and ABH. When you have done that, you can then visit the joint charging standards to see whether or not they fit. And in terms of GBH, we're talking about very serious injury, really serious harm. Fractured skulls, substantial blood loss, permanent disability. Okay, so we're now getting to the nub of it. We're now getting to the difference between section 18 and section 20. And the first thing that I want to do is I want to talk about this issue of causing and infliction. Section 18 covers wounding and causing GBH, as we know, with arrest. So it causing GBH with intent to resist arrest. So the first thing to say is that this charge will be preferred where it's easier to prove. And it is easier to prove, generally, that I intend to resist arrest than I intend GBH. If we go back to my sweet stealing incident at the very beginning of this video, it is easier to prove that I intended to resist the arrest of the police officer, I pushed him out of the way and I ran out of the shop, than it is to prove that I intended to cause him grievous bodily harm. So to that extent, frequently, where it is applicable, the charge will be the causing grievous bodily harm with intent to resist arrest because it's easier. The defendant only needs to cause the injuries in section 18, so the normal rules of causation apply. Okay, so normal rules of causation apply. Therefore, that makes the actus reus of section 18 and section 20 the same, with one exception. Section 18 covers omissions. So you can commit a section 18 by an omission. And the reason for that is that the word cause is used. In section 20, the word infliction is used. And infliction has to be a positive act. You can't inflict something by an omission. So section 18 allows us to have omissions as a method of committing this act. So, we're now there, the star of the show, mens rea. And you'll recall, hopefully, that we have two clear ways of dealing with mens rea issues for offences. The first is to look at the case law that helps us to decide what the level of mens rea is. The second is then all of the subsequent pieces of case law that look at those particular levels of harm. So, in this instance, what constitutes the mens rea of section 18 is defined in Belfon 1976. Once that's been done, we then go to look at the case law that constitutes direct intent, Woolin, Matthews and Elaine, Mohan. We then go to look at perhaps what constitutes indirect or oblique intent, Woolin and Matthews and Elaine. Or we go to look at what constitutes recklessness, Cunningham. Not in this case, obviously, but so we've got two clear stages. The first is, what is the case law that dictates which mens rea should be used for this specific offence? Then we look at the more generic cases that look at the different types of mens rea under criminal liability. And in this instance, our first port of call is R versus Belfon. Belfon tells us what type of mens rea section 18 requires. And in Belfon, the defendant and an accomplice wounded victims with intent. The defendant attacked those who came to help a girl that he had pushed to the ground. He slashed one man with a razor, causing severe wounds to his head and chest. Now, in this instance, Belfon is convicted of a section 20 offence. And he's convicted of the section 20 unlawful wounding because he had certainly foreseen the risk of such consequences, but it had not been proved that he had the specific intent required for the more serious offence. Now, we've got the section 20 for Belfon, but it's what the judge says that tells us exactly what we require for section 18. He tells us that for section 18, we need either an intention to cause grievous bodily harm or to resist an arrest, or that the person foresaw that as a virtual certain consequence of his actions. So, he tells us what the direct intent is and that the indirect intent is. So Belfon tells us exactly what the type of case law is that we require for Section 18. Then when we're dealing with the direct intent, we'll be dealing with Mohan. And when we're dealing the indirect intent, we'll be dealing with Woolin or Matthews and Elaine. Okay, and I'd like, when you're answering questions, I'd like you to approach it in that way. Balfon will tell you what case we require for Section 18. Then, if it's direct, it'll be Mohan. If it's indirect, it's Woolins and Matthews and Elaine. So that's the simple part. This is the complex bit. This is the L'Oreal science, if you like. There are two levels of mens rea. I've already done this at the beginning briefly, but I'm going to go over it again. Level 1 is the wounding or the grievous bodily harm, which must be done maliciously. And that is the same meaning as Section 20. And if you recall, malicious in Section 20 means either intentionally or recklessly. And as I said, please don't allow this use of the word to confuse you about Section 18 being a specific intent crime. That's just level 1. That's the first, that's a rubbish dotted line, that's the first stage that the defendant has to go through. The second level is known as the ulterior intent. So what's the other? Further intent. And that further intent is that there must either intend to cause grievous bodily harm, or there has to be an intent to resist or prevent lawful arrest. The prosecution must prove that it was D's purpose, the defendant's purpose, to cause grievous bodily harm, or to resist arrest, or that he foresaw this as a virtually certain consequence of his actions. So, let's have a look. You've got either an intention or reckless intent to cause grievous bodily harm, which, as an ulterior offence, has the intention to cause grievous bodily harm, or the intention to resist arrest. Or you can intentionally or recklessly wound with an intention to resist arrest, or to cause grievous bodily harm. Now let's go back to our shop again. I can, and this is I'm not going to deny there's an element of difficulty here. It's hard to see how you can recklessly cause grievous bodily harm whilst intending to cause grievous bodily harm. I accept that that is a challenge for anybody to come up with an example of. But let's just have a look. You can definitely recklessly try to, or recklessly cause grievous bodily harm, take me pushing the police officer over, with a direct intent to resist arrest. So I can recklessly push the police officer over, but I can have an absolute intention to resist arrest, and that's the reason why I pushed him over. Easily enough, I can have an intention to cause grievous bodily harm with an intention to cause grievous bodily harm. That seems to be easily straightforward. I could, of course, I suppose, have an intention to wound plus an intention to cause grievous bodily harm. Now you'll notice here that there is no wound. An intention to wound will not suffice for Section 18. And I'll try and explain why that's the case. I can intend, level 1, to wound you. I can scratch the back of your hand with a sharp knife which would cause blood to flow freely. It could be a scratch. I could intend to scratch you with that knife and blood would flow freely. But it cannot be true that you would then be liable, or I would then be liable, for the Section 18, the life imprisonment offence. So what the drafters of the legislation did is they suggested that only really serious harm, or an intention to cause a really serious harm, will do. So if my wounding amounts to really serious harm, then I can be up for the Section 18. So if I was to take that knife and to stab you, the wound would become really serious and the Section 18 Act would apply. Section 18 offence would apply. Now, there are a number of things that help us here. If you're an AQA student, the examining board do not look at, they don't question you on the resisting arrest. So that's useful, because all you need to worry about is really this bit here. You don't need to worry about the intention to resist arrest. But I think it's useful that you know it anyway. And in terms of just making sure you've actually got it, the first thing is that it's the resist or prevent the arrest of you or a third party. I'm missing out words here. You or a third party. The second is you have to be aware of the arrest. And the third is that the arrest has to be lawful. So just make sure, if you are discussing this, you're on a different exam board or perhaps even on the NLB, that you are completely aware that the resisting of the arrest can be the resisting or the prevention of arrest of yourself or a third party, providing that you are aware that the arrest is, or that you are being arrested, and secondly, or that somebody else is being arrested, and thirdly, that that arrest is lawful. Okay, so just make sure that you are aware of that. Now, I hope that that has been clear. The key thing for you to recall is that there are two levels. The first is this idea of causing a GBH or a wounding, either intentionally or recklessly. The second is there must be an ulterior motive, an ulterior intent. And the ulterior intent must be to either cause GBH or to resist arrest. I must actually want to cause you really serious harm, or I must actually want to resist arrest. If I cause you GBH or I cause you a wound, and I do that intending to cause you really serious harm or intending to resist arrest, then the Section 18 Act applies.